Mr. Darrell David.
Mr. Deputy Speaker, question 22, 23, 24 cover issues that relate to the portfolios of both the Ministry of Law and Ministry of Manpower. So may I seek your permission to provide a combined reply to question 22C and question 22D, 23B, 23C, and 24B. The Senior Minister of State for Law, Mr. Edwin Tong, will address the remaining parts of the question. Your permission, please.
Yes, please.
Mr. Deputy Speaker, Mr. Darrell David and Mr. Sito Ipin asked about the consequences for foreign domestic workers, FTWs, and employers, and the recourse for employers when FTWs borrow from licensed and unlicensed moneylenders. I will address these questions together. Where licensed money lending is concerned, FTWs who do not repay their loans may be subject to civil actions by licensed moneylenders, as with any other borrowers. Employers of FTWs are not liable to repay any of their FTWs' loan. It is an offence for licensed moneylenders to harass the FTWs or their employers for repayment, or employ an agent to do so. FTW employers who are harassed should report to the police. We do not condone any borrowing from unlicensed moneylenders by foreign workers. To send a clear signal of our strong stand, the Ministry of Manpower had earlier announced that if a work pass holder is found to have borrowed from unlicensed moneylenders, the employer will be informed and the employee's work pass revoked. The foreign worker would then be repatriated and debarred from further employment in Singapore. The rule against borrowing from unlicensed moneylenders will be implemented in 2019, following a period of education and communication with work pass holders and their employers. We will intensify efforts to help them learn about money management and the risk of borrowing from moneylenders. Any person who is harassed by unlicensed moneylenders should report such activities to the police. From the year 2008 to September 2018, the police registered about 460 reports of harassment by unlicensed moneylenders arising from FTWs borrowing or acting as guarantors. The police and the Attorney General's chambers have prosecuted errant debt collectors who have violated the law and will continue to take strong enforcement action against such conduct.
With your leave, Mr. Deputy Speaker.
Yes, please.
Mr. David and Mr. Sito asked for statistics on foreign domestic workers who have taken loans from licensed and unlicensed moneylenders. Mr. David and Mr. Sito also asked if Ministry of Law intends to place any restrictions on the FDWs in taking such loans. Let me deal with both questions together. The number of FDWs who have taken loans from licensed moneylenders was approximately 1,500 in 2016, 12,000 in 2017, and 28,000 in the first half of 2018. Money lending regulations do not formally define a loan default. However, estimates based on moneylenders' credit bureau data from 2016 to the first half of 2018 show that the majority of FDWs have repaid their loans from licensed moneylenders. The police has also observed more foreigners residing in Singapore, including FDWs, borrowing from unlicensed moneylenders. There are currently several measures to protect all individuals who borrow from licensed moneylenders. For example, the moneylenders rules permit a licensed moneylender to charge only the following for each loan. First, an upfront administrative fee of up to 10%, interest of up to 4% per month, late interest of up to 4% per month, and late fees of up to $60 per month. The Registrar of Moneylenders had issued directions to regulate moneylenders' activities. In particular, moneylenders are prohibited from advertising their loans to members of the public via mobile text messages or emails. Moneylenders are also prohibited from conducting abusive practices such as repeatedly rolling over existing loans to charge the administrative fee multiple times even though no new credit is issued, or offering split loans so that late fees can be charged multiple times per loan each month. In view of the recent increase in foreigners borrowing from moneylenders, on 4th October 2018, the Ministry of Law announced 2 measures to strengthen protection for FDWs and other foreigners residing in Singapore from the effects of overborrowing. First, the Ministry will impose aggregate loan caps to limit the total amount that any foreigner residing in Singapore can borrow from licensed moneylenders. The caps were first announced for Singapore citizens and permanent residents under the Moneylenders Amendment Bill in January this year. And the caps are: individuals earning up to 20,000 a year may borrow up to 3,000, and individuals earning 20,000 or more a year may borrow up to 6 times of their monthly income. Both caps will be extended to all foreigners residing in Singapore. In addition, there will also be a lower cap of $1,500 for all foreigners residing in Singapore who earn less than 10,000 annually. Second, the Ministry will also introduce a self-exclusion framework for all individuals who borrow from licensed moneylenders. Both Singapore residents and foreigners may apply for self-exclusion. Licensed moneylenders will be prohibited from lending to self-excluded individuals. This framework will help individuals to control their borrowing habits and to participate in debt assistance schemes administered by voluntary welfare organizations, which typically also require self-exclusion. The Ministry of Law, together with the Ministry of Manpower and the Singapore Police Force, will continue to monitor the situation following the implementation of these measures and will assess if more stringent measures are necessary. Thank you.
Mr. David.
I thank SMS and SPS for their replies. Mr. Speaker, sir, 2 SQs to ask. It's heartening to hear that there are measures that are being taken with regard to self-exclusion and with regard to the caps. This is pertaining to licensed moneylenders. Would it be useful for the government to consider, perhaps, in light of the fact that the employers are usually the ones who have to suffer the consequences should FDWs perhaps default on their licensed moneylending loans, would it be useful to have a practice where the employer's consent needs to be sought before FDWs approach licensed moneylenders for a loan? So in a way, if you look at the self-exclusion for the casinos, for example, understand that family members can also choose to exclude certain family members if that's a practice. So my question is, can the authorities consider, with the case of licensed moneylenders, for the employer's consent to be sought before the FDW makes that loan with the licensed moneylender? Second SQ is relating to the issue of unlicensed moneylenders. As far as I understand it right now, it is not an offence to take a loan for an unlicensed moneylender. Am I correct, SMS, in assuming that?
That's correct from the borrower's perspective.
Borrower's
It
perspective.
is not legal for a moneylender to carry out their business without a license.
Thank you, SMS. With that clarification, Mr. Speaker, what usually happens then is that perhaps if FDW makes that loan and she then has employment terminated by the employer, understandably, when the employer finds out, she returns. But as she has committed no crime, the FDW is technically able to return to the country again, and perhaps this entire cycle is repeated, by which the FDW then perpetuates further inconvenience and stress on her new employer. So would the authorities consider perhaps in such cases, I understand the concept of innocent till proven guilty, but could we have some measure whereby such FDWs are either placed on a watch list or even perhaps even barred from returning until this matter can be clarified to avoid further inconveniences, shall we say, down the road? Thank you, sir.
Is MOM or? Okay, MOM is answering.
Yeah, MOM is answering. I want to thank Mr. Gerald David for his supplementary question. First, let me assure Mr. David and the rest of the members that while the number of FDWs borrowing from licensed money lenders have increased, majority of them repay their loans, and the default rate remains low. His first SQ is on whether if the FDW goes to a licensed money lender, can the money lender seek the consent of the employer? Am I right? Now, we have considered that, the pros and the cons. At present, MOM has not made it mandatory for the FDW to seek the consent or for the moneylender to do so. Meaning also, we have not made it mandatory for the FDW to disclose their borrowings from licensed moneylenders to their employees, simply because we are concerned that if and when we do so, it may well trigger the FDW towards taking more drastic actions, such as then gravitating towards borrowing from the unlicensed moneylender, just so to avoid telling the employers. So it's a very delicate balance. Now, the second question on if the FDW goes to unlicensed moneylender, what can we do after the employer sent her back? How do we ensure that the question is whether can they be put on a watch list? This is where earlier MOM, in support of MinLaw's new measures, we have said that in order to deter FDW from borrowing from unlicensed moneylender, come next year, we will effect the debarment measures after a period of education and communication with FDWs and also employers, as well as other stakeholders who could be affected. And we will announce the effective date at a later time. Now, when the debarment measure comes into effect, what will happen is the debarment period set is based on the facts of the case, right? But allow me to also add that and reassure the member that MOM, we will step up our education efforts to the FDW first for new FDW through our settling in program to share with them the importance of money management and also the risk and implications of borrowing, over-borrowing, and the borrowing from moneylenders, in particular unlicensed moneylenders. And here we would like to appeal to all employers of FDW to also share the importance of money management and the risks and implications of borrowing. Thank you.
Mr. Luisen.
Thank you, sir. Can I just ask SPS whether MOM is actually studying why the FDWs are borrowing money while during their employment in Singapore? What are the main reasons? If we're not studying, can I ask whether MOM is willing to conduct this study so that we understand what the root of the problem is and then we can really address it?
I want to thank the member, Mr. Louis Ng, for his question. Yes, we have been looking into all the possible reasons, and anecdotal evidence tells us that in certain cases, FDW will borrow a certain amount from the licensed moneylenders to tide through certain requests from home, such as unforeseen medical bills or paying for college fees for their children, etc. And they need to borrow this amount of money for a month before they receive their next paycheck from the employers. We are thinking through, and we will certainly consider mounting a study to understand a bit more about this. Thank you.
Mr. Lee Chia-sing.
I'd like to highlight that there are a lot of unlicensed moneylenders that actually pass off as licensed moneylenders, and even, not to mention FDW, but even my residents, sometimes they receive SMS from unlicensed moneylenders, they just go ahead and borrow money from it and turn out to be unlicensed. So the measure of sending them back seems very drastic because the FDW may not know, and can we exercise some flexibility whether, if with the consent of employer, they actually can continue to stay in Singapore? Thanks.
MOM.
Two parts to the question. So first, we will intensify the education efforts to help FDW understand who are the licensed vis-a-vis the unlicensed moneylenders. Now, for employers who wish to continue hiring their FDWs who are debarred, for various reasons, maybe because they are pending the arrival of a new FDW, they can certainly put in a request to MOM, and we will look at it on a case-by-case basis.